The trial chamber that I was in was the first trial chamber ever to deal with certain crimes of gender-based violence, sexual slavery and forced marriage as a crime against humanity. And we also were the first court to ever deal with child soldiers. So the evidence that came in the special court showed that rebel groups would move into a village. They would round up the people. They would separate the able-bodied men, women, from the older or the less, let's say the disabled or the people that weren't strong. Mm-hmm. They would select, and I remember one witness describing it as the good-looking girls. Mm. They would quite often publicly rape those women. They would, on occasion, force groups to, family groups, for example. They would tie the women down and force their relatives to have sex with them. The descriptions were of great humiliation and great pain. In the first trial, we found that the group we were dealing with, the armed former soldiers in the army, were not committing public rape for anything other than their own sexual gratification. Mm. But in subsequent trial of Charles Taylor, where we were also taking evidence of the armed force, the Revolutionary United Front, who also practiced going into villages, rounding up the people and publicly raping the women, we found that it was a deliberate psychological tactic and was a terror for terrorizing the people. And we ruled that rape was being used as an act of terror, an act of war. Mm. And the other trial chamber, trial chamber 1, that had dealt with the Revolutionary United Front leaders, in that trial also ruled that rape can be an act of terror, and therefore a war crime, as opposed to a crime against humanity. So our trial chamber was the first, as I said, to deal with sexual slavery and forced marriage. Forced marriage had never been a crime in any of the international tribunals, but the prosecutor in our case put that in the indictment. Mm. The evidence showed that these young women, older women and girls, were rounded up. They were taken back to the camps where the rebels were living, and those camps moved from one place to the other. Mm. The women would be divided into two groups. One lot would be allocated to rebels, maybe commanders, maybe junior men, and, according to the evidence, young girls, 8, 9, that sort of age group, were given to the boy soldiers. The boy soldiers were called SBUs, Small Boys Units. Those women that were allocated to specific men were the exclusive property of those men. They were told that they were married to them, and they were the wives of those men. Nobody else could touch those women. If the rebels that they were allocated to, if they were commanders, those women had a high status in the rebel movement, and they would sometimes have even young girls or young boys allocated to them to do their cleaning or washing. If they were allocated to more junior men, then they had to work. All of them had to look after the man's possessions, and as the group would move from one district to another, they had to carry all his possessions. They were exclusively the property of those men. If the man got fed up with that girl and wanted another girl, wanted some more girl, or wanted to get rid of her, normally they were sent to the front lines to fight, and they were killed. The other women that weren't these exclusive property, they were available to anybody, and they were frequently gang raped, often on a nightly basis, daily basis. And they also had to work for anybody who wanted cleaning or laundry or cooking done. And when we came to decide on whether forced marriage was a crime, my two colleagues said no, it was all the same. And I said no, they were different. They were different because the women were treated differently, and the impact on the women psychologically was different, and also quite often the women could not go back to their own communities because they were the property of these men, and their community would not allow them to return. So there was a particular stigma that they suffered. And on that basis, I said this was contrary to certain conventions, to certain international, to different laws in different countries, and I drew analogies to the laws in, if I remember correctly, I looked at Nigeria, I looked at Australia, I looked at India. I had to draw from different civil and common law jurisdictions, and I said I dissented and said it was a crime. Forced marriage was a crime against humanity. And I also said that sexual slavery was already in our statute. And the appeal chamber agreed with me, with my dissent, and forced marriage is now a crime against humanity. And I also disagreed with how procedurally the crime of sexual slavery had been differentiated by my colleagues on a procedural basis. They excluded it, and the appeal chamber also upheld that dissent. So as a result, those two crimes, we were the first international tribunal to declare or call those, convict anyone for those two crimes. We looked to the ICC statute, for example, for the definition of rape and the definition of sexual slavery. But at that point, the statute was in existence, but there had been no charges in the ICC. But we did use their definition. But there's no forced marriage in the ICC.